usually investors, when they come on board, the relationship starts off really great. They've just put money into your company, they're very excited, but ultimately they are going to protect their own interests first.
Welcome to the Startup CEO Succession podcast, where we dive deep into the pivotal journey of founder CEOs who face the critical decision: should you continue leading your business or bring in a new leader? I'm your host, Evgeny Shadchnev. As a founder, coach, and author specializing in CEO succession, I interview founders, chief executives, and investors who share their stories of navigating this transition. Today, I'm speaking with Gretchen Lennon, a UK qualified lawyer with particular expertise in equity incentives, EMI, options, and other topics which often come up during CEO succession in startups. Gretchen and her team offer no-nonsense, cost-effective legal support to startups and scale-ups in the UK. I had the chance to work with Gretchen many years ago when I was still running Makers, my own business. In our conversation today, Gretchen and I will touch on many specific technical legal aspects that founder CEOs considering stepping down should be aware of. For example, the difference between shares and share options and their tax treatment, the timing of the resignation, how to negotiate a settlement agreement, and why settlement agreement matters even if the departure is amicable. I really hope you enjoy this conversation. Good morning, Gretchen. Thank you so much for joining me today.
Good morning, Evgeny. Thanks so much for having me. It's a real honor.
Thank you. So today we're going to have an interesting conversation about various legal aspects of CEO succession in startups. But before we dive in, I wanted to make a couple of disclaimers. The first one is that quite obviously nothing we're going to say is going to be a legal advice for anyone listening. For legal advice, please speak to your lawyer or reach out to Gretchen. And the second thing is that even though a lot of things that we will say will be applicable to companies in various jurisdictions, we will assume that hypothetical scenarios we will be discussing are companies headquartered in the UK, operating under the English law, and their founders are also UK-based taxpayers where taxes are concerned.
Sounds good.
So, cool. So with this out of the way, Gretchen, let's start with a hypothetical scenario. Let's imagine there is a startup and the founder CEO has been running it for the last 5 or 7 years. They maybe raised a Series A, and for whatever reason, they believe they are no longer the best chief executive for their business. And they're about to approach their board and have a conversation about it. As a lawyer, what would you like them to know from a legal perspective at this point?
I think as a lawyer, I would usually recommend that a founder who's considering taking this decision has a discussion with their lawyer initially. When I say their lawyer, there's maybe a bit of a conflict because typically the company will have a relationship with a law firm, maybe more than one law firm. Unfortunately, if they are the lawyer for the company, they're not probably going to be able to be your lawyer as well. That being said, you're probably not yet at the stage where you need to get your own personal lawyer, but I think before you have a conversation with the board, you probably want to have a good understanding of what the legal position is, what a resignation would mean for you in relation to your shareholding in particular, because that's primarily going to be where the most value that you hold in the company is. And then also thinking about what are the sort of circumstances or reasons that have led to your decision for potentially resigning. If it simply is just a personal decision, you've built this up over the last 5 or 7 years and you're ready to move on, you're maybe, as you say, Evgeny, no longer the right person to lead the company into its next chapter, then that's fine. And it sounds like that would probably be quite amicable. However, if there's actually something a little bit more acrimonious going on, if you feel that maybe you're being pushed out or there are decisions being made that you're no longer happy with, then you might even potentially be looking at constructive unfair dismissal case, which has led to your resignation. And in that scenario, then definitely you're going to need a lawyer who's going to have to be different to the company's lawyer. So I would say, as a starting point, try to have an informal conversation with a lawyer. Maybe the company's lawyer to start off with, but at some point you're probably going to need your own.
Yeah. And there are two important points here. The first one is that you're alluding to a conflict of interest, because if a lawyer is acting for the company they can't simultaneously act in the interest of the founder. Also, you spoke about a constructive dismissal case. Could you elaborate on this? What does it mean?
Sure. So constructive unfair dismissal is a particular type of unfair dismissal claim in UK employment law, and it arises where an employee has resigned as a result of the behaviours of the company that have effectively made the continuing employment relationship untenable, where you feel like you've been pushed out, where you have resigned because you felt like you had no other option. If you're in a position as a founder where you're getting to that stage, then maybe before you make the decision to actually hand in your notice to resign, it would be a good idea to speak with a lawyer who has an understanding of constructive unfair dismissal, but can also advise you on your share options and your shares, because that's probably going to be your main concern, really, if you were to walk away, to make sure that you walk away with the most value possible.
So what you're saying is that if a founder CEO feels like they can't really continue in their job because the board or the investors are acting in a certain way, and then they just go and resign, it might not be the best course of action because there might be a case for a constructive or unfair dismissal, and it's worth discussing it with a lawyer.
It could potentially lead to, or it may mean that the founder in question has a right to bring a constructive unfair dismissal claim, but it's definitely worth getting a little bit of advice on that before you pull the plug and hand in your notice. I realise we've sort of started off on a slightly negative note. That's obviously where circumstances are not amicable. Of course, if it really is just a circumstance where, as you described, you've just decided that it's time for you to move on, it's time for your next chapter in your life, and maybe you're not the right person to take the business forward, then even if it is completely amicable, before you start having conversations with the board, you probably want to have a good understanding of what it means for your equity if you were to resign. And the answer to that question would typically be set out in either the company's articles of association, maybe the shareholders agreement. Indeed, if a lot of your equity is still tied up in share options as opposed to actual shares, then you probably also want to take a look at the share option plan rules or whatever other documentation refers to the options that have been awarded to you. You may feel quite comfortable, particularly because you may well have been involved in the drafting of them at the time. So you may feel comfortable enough that you can understand yourself what it means. That being said, it's probably worth just speaking to someone who has a bit of legal expertise in these areas, and they can just very quickly take you through the drafting and let you know, okay, in this circumstance, you are likely to be considered either a good or a bad leaver. If you are a good leaver, then ordinarily you would be able to maybe keep your vested shares, but may have to transfer back your unvested shares, or perhaps you may have to transfer back all of your shares. And then the question arises of what would be the price that you have to transfer or sell back any of your shares for. All of those would typically be set out in those documents that I mentioned, but it's definitely worth getting a lawyer to give them a quick once-over for you.
Yeah. And you just mentioned that there are two separate sets of documents. One set of documents describing what happens to the shares that founders probably subscribed to when the company was formed. And the other set of documents relates to the share options, which the founder might have been granted during the company's operation.
That's exactly right. Typically, when a founder sets up a company, they effectively would have awarded themselves shares on incorporation. And over time, that shareholding might have got diluted down as you have done more and more funding rounds. And in addition to the shares that you hold from incorporation, it's quite common that founders or senior executive or senior leadership teams are also granted top-up equity in connection with funding rounds. However, generally, if an employee, founder or any other employee, were just to be awarded shares up front, there would be a tax consequence. So in order to minimize or delay any tax payment, or maybe possibly even avoid it altogether, any top-up equity that is granted may be in the form of share options. And sometimes those share options are not actually exercisable until a later exit event or liquidity event. So it's not unusual to see on a cap table founders and other members of the senior leadership team holding shares, which are typically their shares from incorporation, and then also holding share options, which are usually part of their top-up equity from funding rounds. So you would usually want to take a look at both the Articles of Association and the Shareholders Agreement. Those are the documents that govern the ownership of shares. And then with regards to the options, you would typically want to take a look at the share option plan rules, or maybe the share option agreement, or whatever documents govern the share option ownership. It may be that the leaver provisions in those two different sets of documents are themselves different. So you might be a good leaver under one of the sets of documents, but actually not a good leaver under the other.
What happens to share options if the founder leaves the business before an exit?
It's a really good question. And the short answer is it completely depends on the drafting of the share option plan rules or the applicable share option documentation. With EMI options, which are a specific type of tax approved or tax advantaged share option for employees, if the founder holds EMI options, it is common, if you are a good leaver, you may be allowed to exercise your vested EMI options within a certain period after termination of employment. And typically that period is 90 days. That's the window during which your EMI tax benefits are still preserved. If you exercise your EMI options at any point after 90 days after termination of employment, there would usually be an income tax charge on any increase in the value of the shares from the date that you left employment up to the point when you eventually exercise. So if you exercise within 90 days, they're taxed as EMI options, which means usually, provided all of the other EMI statutory requirements are met, that there should not be any income tax when you exercise. However, if you either choose to or are required to simply hold on to your vested options and wait until an exit event, it is likely that there would be an income tax charge.
But before the exit happens, exercising options means buying shares that are covered by those options. So the founder would need to offer cash to the business in order to exercise.
That is the case. That can sometimes be the reason why departing employees or departing founders find it difficult to exercise their options within that 90-day period post termination of employment, particularly if the EMI options have been granted in connection with a later funding round. So that would usually mean that the exercise price of those EMI options would be a discounted price to that share price from that funding round. But it may still be a sort of not immaterial amount, in which case, assuming that the plan rules allow it, you may choose to just keep those vested options and wait until there is an exit or another liquidity event, at which point you'll have the cash to be able to pay the exercise price.
But at this point, you might have an increased tax liability.
That's exactly it. Yeah. Well, I say it's a balancing act. If the documents are very clear that you have a 90-day window to exercise your vested options after termination of employment, and after that, the options lapse. If there's no already pre-built in board discretion to allow you to keep the options, if you don't exercise within 90 days, they will lapse. So these are definitely the kinds of provisions that you want to speak to an expert about, so that you've got a very clear idea of what is going to happen when you terminate your role as CEO. In some cases, this could be into the sort of tens to 20 thousands of pounds, or maybe even more. A lot of departing founders, they're quite wealthy. They've got a sort of a not immaterial stake in a company that is getting some pretty nice looking valuations, but they haven't yet actually been able to realize the cash value of any of that equity that they hold. So it can be quite difficult to stump up 10, 15, 20 grand.
And you also mentioned a potential for transfer of some of the vested shares or share options back to the company. Can you say more about this?
So it is not common to transfer options. In fact, generally speaking, options that have been granted to employees are non-transferable. So with options, either you exercise them or you keep them or they lapse. But with shares, you can't transfer them. And it is quite common that the Articles of Association, or perhaps the shareholders agreement, would include certain provisions. They're sometimes called leaver provisions or compulsory transfer provisions, which would effectively require you to sell or transfer some or all of your shares either back to the company or maybe to a third party. It could be an employee benefit trust, or it could even be directly to your successor, or perhaps even to some of the other shareholders or investors. The price that you might be entitled to receive for those shares would again be set out in the relevant documents. Fairly common or typical drafting would be something along the lines of, if you are a bad leaver, then you may be required to transfer some or all of your shares back to the company for the lower of fair market value or nominal value, you're basically getting next to nothing. Conversely, if you are a good leaver, typically you would be entitled to the higher of fair market value and nominal value. In terms of who actually determines what fair market value is, the documents should set that out. Quite often you'll see in Articles of Association fairly detailed provisions around how fair market value is calculated. You might see language that says fair market value is as agreed between the transferor and the company, or where no agreement can be reached, it's as determined by a third-party expert.
And how often does it happen?
It's a very good question. In the context of departing founders, it probably doesn't happen that often, I would say, not least because the fair market value for the departing founders' equity is one element of the overall negotiation of the sort of termination package. Usually the company will try and sort of hash it out with the founder, not least because it keeps costs down. Ideally, you would, between departing founder and board, be able to reach an agreement. But that's not to say that it happens smoothly every time.
And one potential complication I can think of is that the last round price is attached to preferred shares, and preferred shares will have additional right there higher in the liquidation stack. Then argument can be made that ordinary shares that the founder most likely holds are not equal to the latest pref shares, and therefore the last price should not apply.
That would be one of the factors that would be part of the negotiation on what is fair market value. At this point, unfortunately, the departing founder probably is not only going to have to appoint their own lawyer, but maybe have to appoint or speak to their own sort of accountant or tax advisor as well.
And can you explain the difference between a lawyer and a tax advisor in this situation?
The short answer is generally there would be at least two people that the departing founder would need to speak to, not least because lawyers are not advised or authorized to give tax advice, and accountants are not authorized or regulated to give legal advice. Unfortunately, whilst there's a lot of sort of meeting in the middle of the two different advisors, they can't really cross over and advise on each other's territories, unfortunately.
And I get a sense that this is the point at which it might become expensive for the founder. So now there are two professionals and they've got to be paid by the founder. Or can the company cover those costs?
So that's a very good question. It is possible for the company's accountants to also give tax or accountancy advice. I believe that there isn't so much of a conflict of interest. So it is possible for a tax advisor to also give a sort of high-level advice to an individual about what would be the personal tax consequences of their departure and the package that they're being offered. Whereas lawyers, unfortunately, because they're considered to be two conflicting parties, they cannot advise both parties. With regards to whether the company can pay the departing founder's fees, the answer is yes, and it is quite typical. It is market practice for the company to contribute towards the legal fees of the departing employee, depending on how contentious the termination is and how senior the employee is. But for someone who's an outgoing founder, I don't think it would be an unreasonable expectation that the company should, be contributing sort of four figures towards their legal fees.
And speaking of the settlement agreement, it sounds like it's a common legal instrument by which founders are leaving their business. Or am I wrong about this? Can a founder just sort of resign instead of negotiating a settlement agreement?
They can, absolutely, but it's generally in both parties' interests to get a settlement agreement in place. It sets out very clearly exactly what's been agreed in terms of the termination package, also exactly what's going to happen to the equity, whether it's being bought back, at what price, when that's going to happen, albeit there probably would also be a separate buyback agreement. But more crucially, from the company's perspective, the settlement agreement acts as a waiver of claims. So in essence, it draws a line under any and all claims that the departing founder may have had against the company, particularly if there's anything acrimonious about the departure. And if there is the potential for any sort of unfair dismissal claim or any other type of claim, whether it be discrimination or whistleblowing or harassment or bullying, victimization, anything at all, signing a settlement agreement effectively acts as a waiver of all of those claims. One caveat to that point, however, is that it doesn't waive the claims for the termination package. So even though you waive any sort of historic or previous employment-related claims, you're not actually waiving your claim to the good leaver treatment or the sort of the buyback of your equity or whatever it might be that's been agreed as part of your termination package.
But what I'm also hearing from you is that it's a good idea to sign a settlement agreement for a departing CEO, even if the departure is amicable.
It's certainly not mandatory, and some companies may choose just to not bother. The parties may go into the settlement discussions, or indeed come out of the settlement discussions, feeling a lot of trust and feeling very comfortable that both parties have agreed that they're going to get what they want. As a lawyer, of course, it's sort of slightly raises the hairs in the back of my neck, because really, from a legal protection perspective, having the settlement agreement in place sets out exactly what both parties have agreed, but it also acts as that absolute sort of draw a line under any prospective claims type issue. And in particular, if a company is about to go into a funding round or perhaps into an exit, the incoming investors or prospective buyers may be interested to see that a settlement agreement was put in place with a departing founder, so that there's very unlikely that anything is going to come back from that. I'm conscious to not over-egg this point too much, not least because with settlement agreements, typically they're mostly capturing employment-related claims, and any departing employee, whether it's the founder or otherwise, actually only has a 3-month window after departure in which to bring a claim. And so if more than 3 months has elapsed since someone has left the employment, typically they wouldn't really be able to then turn around and try to bring a claim for unfair dismissal or discrimination. It's not necessarily something that is still offering a huge amount of protection 5 years down the line, but it's a neat way to sort of resolve all negotiations with an outgoing founder, and also have a formal record of what was paid and what was agreed as well.
And I imagine there are other questions that arise at this stage. For example, whether a founder can hire their ex-colleagues for their new venture, whether they own the IP for their side projects.
Thank you very much for bringing that up. And indeed, that can sometimes be a point of negotiation. When you come to, or a founder comes to resign, one of the provisions that they may be, or one of the issues that they may be concerned about, is the limitations on their freedom to go off and do the next thing that they want to do. When these sorts of post-termination restrictive covenants are put in place, when they're drafted into employment contracts or director service agreements, they're there to protect the business from the risk of a departing employee either going and working for a competitor or taking valuable team members or valuable clients with them. One of the points to raise with your lawyer when you're sort of having these sort of initial conversations around what do I need to think about when I go or when I resign is, what is it that you want to do next? And so one of the tasks for the lawyer that you speak to is to really do a deep dive into the drafting of those restrictive covenants, give some consideration to what the scope of them is, whether or not what it is that you're planning to do is likely to fall into that scope, and then also give some consideration to whether or not the drafting of those restrictive covenants is likely to mean that they're even enforceable in the first place. One of the sort of principles of UK employment law is that any post-termination restrictions on departing employees can only be as wide as is reasonable to protect the business's legitimate business interests. It's a very sort of long-winded way of saying you can't cast the net so wide that it basically restricts someone from effectively ever getting a job again. If the drafting is extremely wide, then your lawyer might actually advise you that they're unlikely to be enforceable. So if it is the case that you want to go and work for a competitor or want to take your team with you, you may consider that actually on your lawyer's advice. If they're unlikely to be enforceable, you could just take the risk and do it anyway. But then that sort of changes the tone of the sort of amicable departure and can also potentially even have an impact on whether or not you're treated as a good leaver or bad leaver.
So this is why specific tailored legal advice is crucial.
I mean, I know it sounds like I'm sort of blowing the lawyer's trumpet here. Oh, speak to a lawyer. But in this scenario, there are quite a few different strands that you want to make sure you all pull together at the same time to sort of land at the best possible outcome for you, both in terms of, what package are you getting, what happens to your equity, what price are you getting for the equity that you have to transfer back, and then also what restrictions, if any, are still likely to be enforced against you in terms of,
This becomes a negotiation between the founder and the board. So both of them are trying to figure out what each party wants, and in the process, they also determine what sum of money, if any, is attached to the settlement agreement in consideration for everything that the settlement agreement covers.
Yeah, that's exactly right. It's a negotiation between the CEO and the board, because quite often when you get to Series A or possibly beyond, it's fairly likely that your board will not only have, you and maybe your co-founder or some other sort of members of the senior management team or senior executive team, but it's likely to also have one, if not two, investor directors on the board, possibly also a few non-exec directors. And so it's maybe not so skewed in your favor anymore. You're suddenly dealing with some real heavyweights, particularly on the investor side. Usually investors, when they come on board, the relationship starts off really great. They've just put money into your company. They're very excited. But ultimately, they are going to protect their own interests first. And so to the extent that anything does become a little acrimonious, then you may find that actually the investor directors and then their lawyers, who may also get involved in the conversation, can become perhaps intimidating, and it becomes a bit of a them and us situation. There's a group of people on the board that you're no longer a part of, or you're stepping away from, and then you may find the experience quite isolating. You suddenly feel like the kind of team of support that you were part of, you're now on the outside looking in. And so for that reason as well, I think it's probably quite important to find your own support system as you go through this, not just in terms of your own personal support system, family, friends, etc., but also your own separate advisors.
And so far, we've been implicitly assuming that the founder is about to leave and then focus on something new, and they will have nothing to do with the business. How is the situation different if the founder stays involved? So they are stepping down as the CEO, but maybe they will stay as a non-executive director, as was my case, or an advisor, or freelance consultant, or even join their own senior management team, reporting to the new CEO?
It's a really, really good question. And you're right, it completely shifts the conversation. Firstly, in terms of equity, because I know that we've been kind of focusing on that quite a bit. Generally speaking, the leaver provisions, so whether you are a good leaver or a bad leaver in both the Articles of Association and likely also the share option plan rules as well, although there may be a few caveats to that. Generally speaking, those provisions will state that you are a leaver if you cease to be an employee or otherwise engaged by any group company. And that sort of or otherwise engaged by any group company language basically captures the scenario that you've just described, where you step down as CEO and you're no longer a full-time employee of the company, but you maybe transition into a board advisor or non-exec director role, or maybe you kind of become re-engaged as a consultant, or indeed, as you said, maybe you actually stay as an employee, but you're just simply not the CEO anymore. In all of those types of scenarios, again, depending on the specific drafting of the leaver provisions in the relevant documents, but generally speaking, in all of those scenarios, you wouldn't actually be a leaver. So your options would continue to vest on the same vesting schedule that you've currently got. The shares that you already hold, you would typically continue to just hold that as if nothing had really changed. Of course, all of this depends on the actual drafting of the document, but that's a fairly common outcome, in that you may step down as CEO, but still very much remain employed or otherwise engaged by the company or by the group, in which case your relationship with the company hasn't terminated, so you're not a leaver.
Right. So there is quite a lot of complexity here. A person could be a good leaver or a bad leaver, and I've even seen intermediate leaver clause in some documents. And the person can also be not a leaver in the first place, even if they are stepping down as a CEO. Maybe they're staying involved
or
otherwise.
Step sideways. Then if you still have an ongoing relationship with the company, chances are you may not be a leaver at all. In which case your equity may be unaffected.
This can impact the situation with EMI options, because then the 90-day window doesn't start in the first place, and the person can...
Well, it actually very much depends on what's happening with your role, because technically speaking, EMI options are only available to employees. So if you were to transition from a role as an employee to a non-exec director, for example, or an advisor or a consultant, you would no longer be an employee, meaning your options would no longer be eligible for EMI tax benefits. So again, depending on the language in the plan rules themselves, you may be entitled to exercise those vested options within that 90-day period of the transition from one role to another to preserve those EMI tax benefits. Or in fact, you may not be able to do anything with the options. You can just keep them, but from the date that you cease to be an employee up to the point when you eventually exercise them, even if you're still a NED or a consultant of the company at that point, there is likely to be an income tax liability on the growth of the value of the shares from the date when you stopped being an employee to the date when you exercise.
Right. So again, there is quite a lot of complexity here, depending on everyone's exact situation.
Yeah, very much so. And some companies may sort of speak to an employment law advisor and take the view that actually there is no need to get a settlement agreement. They'll simply just issue you with a letter of termination confirming that your employment has terminated, and then sort of, in the very next breath, issue you with a non-executive director appointment letter or service agreement, or possibly even a consultancy agreement if you are genuinely moving from an employment relationship to a consultancy relationship. The reason I sort of put the emphasis on genuinely is simply giving someone the label of consultant or contractor or freelancer doesn't necessarily mean that they are, in fact, not an employee. And of course, consultants, advisors, freelancers are typically paid gross, but they themselves are personally responsible for their own tax liabilities. HMRC have they've come down quite hard on using these types of relationships as a means to circumvent the payment of tax, and in particular the payment of employers' NICs. And so if you are considering transitioning from an employment relationship to a sort of a non-employment relationship, it's certainly worth getting advice from an employment law expert to confirm that actually it is a genuinely different relationship, or is it just you've gone from full-time employee to part-time employee, in which case should you still be paid through PAYE? But that is a completely separate question. But again, another thing to think about.
And Gretchen, one other question that arises at this point is how do you rebalance the cap table? Because the outgoing founder has lots of shares, and I imagine
quite a large chunk of equity. And that's particularly important, I think, in the scenario where you described that if someone is stepping down as CEO but not actually a leaver, and therefore, the leaver provisions haven't kicked in, subject to what it says in the documents, they may not be under any obligation to transfer any of their shares back to the company. In which case, you could have a departing founder who, I don't know, maybe let's say still holds 10 or 15% of the company, and they take a step back to, let's say, non-exec director, non-exec chairman, which really only entails, I don't know, a couple of days a month worth of work. It is likely that the board and certainly the investors will very much consider that they are holding far too much equity in comparison to their contribution to the company. And in particular, the company will be keen to claw back some of that equity so that they can reallocate it to the employee option pool or the incoming CEO. If you are a leaver, you're genuinely leaving, then the documents will give the company the right to buy back some, if not all, of your equity, either at nominal value or fair market value, depending on whether your equity is vested or not. And the reason for these buyback provisions is exactly as you have described, to rebalance the cap table and make sure that a departing founder doesn't sort of disappear off, to the Algarve, to life on the beach with far too much equity. Whereas if you are not actually leaving, but you're a non-exec director, then the documents may already provide that if you are not working full time, that there are compulsory transfer provisions. But if they don't have that nuance in them, then it really is a point of negotiation between the company and the departing founder. And in that instance, the departing founder actually holds a lot of the cards, because without there being a contractual obligation to transfer the shares, it really is just a sort of a very polite request for the company and kind of do the right thing decision on the part of the founder.
So even in a situation where the transition is very amicable and the founder, let's say, wants to step down and maybe join the senior management team to be responsible for one functional area instead of leading the entire business, there is still a case for negotiating with the board, possibly around equity and other points, even in a situation where everyone is on the same page about the CEO transition, why it's happening, and
yeah, very much so. Take the scenario where the company is growing from strength to strength and the CEO just simply recognizes that they themselves are no longer the right person to continue to lead the business, but they would like to move into maybe a COO role or just leading one particular division. If they're still going to be working full time, there isn't really going to be many other changes aside from just the sort of the day-to-day role that they're doing, their job title, maybe a change in salary, but possibly not, then the conversation around equity is pretty much going to be the main conversation. There's no termination of employment. There's no settlement agreement. Likely there are no leaver provisions. In fact, indeed, there wouldn't be. Your employment is not terminating. It's simply just changing. Then it's almost as if the board would be coming to you and politely asking you to agree to give up some of your equity. And then, there would have to be a conversation around how that would be structured. Would you agree to simply convert some of your equity into deferred shares? Would you sell it back to the company for fair market value? And then what are the tax consequences of you doing that? Again, depending on how the buyback is structured, there may be income tax, or it may be taxed as a capital gain. Or you may simply be asked to agree to hold a portion of your shares effectively on trust for, maybe the next incoming CEO.
So if a founder stays employed but in a different role, not as a CEO, it puts them in a fairly strong negotiating position because they're not leaving, they're not resigning, but the board might be interested in rebalancing the cap table, and it could be an opportunity for the founder to both extract themselves out of the CEO role, stay within the business, and maybe get a bit of cash for some of the shares that they're
Cash
giving
out
up.
some of their shares. Yeah, exactly that. If a company is buying back shares from any shareholder, one of the key requirements is how they are funded. In particular, does the company have sufficient distributable reserves, i.e. profits, to pay for this buyback? And if it doesn't, then there are other routes to fund the buyback. They're a little bit more complex. And again, you probably want to have a conversation with the company and the company's lawyers and maybe even the company's tax advisors or accountants to consider whether or not now is the right time to do that buyback. Or if it's anticipated that the company's going to have more profits, in 6 or 12 months' time, maybe delay the buyback and do it at a later stage.
Yeah. So again, lots of complexity here. I also heard the term anti-embarrassment provisions that sometimes comes up at this stage. What are those?
So an anti-embarrassment provision says if you sell shares, the person who has bought those shares from you agrees that if the shares are sold within a certain period of time, i.e. 6, 12, maybe even 24 months, in particular in the context of an exit, if they are sold for, a certain uplift, i.e. more than 50% more than what you received for them, or even just any uplift at all, then it is agreed between you and the buyer of those shares that you will get a proportion of that uplift. So it's basically to protect that seller against a scenario where they lose out on a potentially very large windfall because they were under some sort of obligation, or maybe not an obligation. Maybe they just entered into an arrangement where they sold their shares too early, in essence. So it might be possible to agree with the company that as an anti-embarrassment provision, if X event occurs within 6 months or 12 months, that means that the shares are realized for a significantly higher cash value than the person who sold those shares, i.e. the departing founder, may have a contractual right to some of that uplift.
Yeah. So a specific scenario I'm thinking about is a founder steps down and they're forced to transfer or to choose to transfer some of their shares, and they agree with the board, or the board agrees to appoint a new CEO with a specific mandate to sell the company. Mm-hmm. And then they do an incredible job. 9 months later, they sell the company and there is a significant uplift. And this is the moment when the CEO who resigned 9 months before can come back to the board and say, I'm entitled to additional compensation because of anti-embarrassment provisions.
Yes, if the anti-embarrassment clauses were negotiated into, call it a settlement agreement, or indeed maybe the share buyback agreement, they would have to have been negotiated at the point that the departing CEO sells their shares or transfers their shares. So if you are concerned about an event like that taking place, and I don't just mean the sort of the hypothetical. I think that if you are going to try to negotiate anti-embarrassment provisions, you want to be able to point to an event that you know is quite likely to be on the horizon in the not too distant future. That is going to have a significant impact on the value of the shares, whether that's an exit or maybe securing a patent application or whatever else it might be that really sort of takes the company to the next level valuation-wise.
Yeah, so the key here is to negotiate it before the founder CEO steps down and not later.
Definitely.
And Gretchen, I imagine that during this process, a number of other changes need to be made to the shareholders agreement and the articles, because they probably have some clauses that give founder or CEO, and there might be a difference here between them being a founder and them being a CEO, granting them some rights, for example, being on the board or vetoing certain decisions. And these also, I imagine, become part of the negotiation process.
That's a really good point. In the scenario that we're discussing, where a CEO steps back and maybe moves into a less senior role, then it is probably no longer appropriate that they have that kind of decision-making power or indeed veto power over things like the issuance of new shares or the change to articles of association or maybe the increase of the share option pool. They're maybe no longer the right person to have those powers. If the documents don't contain any sort of automatic provisions for what happens if founders take a step back, then probably we would need a deed of amendment to those documents. And indeed, it might not even be the shareholders agreement. It might be the articles where these particular provisions are set out.
And one particular point that I think will be helpful for founders to be aware of is that there is a difference between their consent right as founders and their consent right as CEOs. And therefore, if they step down as CEO, they might give up some of the rights, but other rights associated with them as founders might still be in place, and this becomes a topic of negotiation.
That's exactly it. It may be that there are specific provisions in the documents that say, X, Y, or Z decision has to be made with the consent of the CEO. If that's the case, then if the identity of the CEO changes, then the drafting itself doesn't have to change. It's just the new person steps into that role, and then it's the new person who has the consent right of the CEO, to the extent that there are sort of CEO consent provisions in the relevant documents. But to your point about the founders, if the founders are identified as the individuals who are the founders, and they themselves have, or the founders are given certain decision-making authority or certain consent rights, then yes, it becomes a point of negotiation with the board whether it is still appropriate for a founder to have those consent rights if they are no longer in the position of seniority that they were once in.
Right. Gretchen, we've covered plenty of topics today. What else we haven't touched on yet, which is very relevant to this conversation?
Typically, I would say that where the founder's decision to step back or step down or step aside is for their own personal reasons, and it's likely or expected to be amicable, I would probably recommend maybe sort of set the wheels in motion a little bit sooner rather than later. I don't necessarily mean go and tell everyone and set hares running, but have a think about the order in which you might want to kind of have conversations. Start off by getting informal legal advice and make sure you're well versed about what your position is. Then maybe have a conversation with perhaps some friendly board members who might help you then take that conversation to the rest of the board, and then obviously take it to the rest of the senior management team and whomever else. One other thing, if this is something that you think you're likely to want to do in the next couple of years, but it's not imminent, but maybe the sort of trajectory to exit for your company is 7 to 10 years down the line, and you've already been slugging away for 5 to 7 years, and you just think, you might be done soon. You might not stay all the way to exit. It's probably important to have a think about what that means in the context of future funding rounds, and in particular, any vesting provisions that may be imposed on your equity in the context of future funding rounds. So it's quite typical when companies go through funding rounds that their existing documentation, so their articles, their shareholders agreement, may be either amended or completely redrafted. And in either scenario, it's fairly typical that incoming investors will want to know that the senior leadership team is locked in for whatever duration the investors want them locked in for. And they do this by imposing vesting provisions or vesting terms on your equity. It is a point of negotiation at the time that you're doing the funding round, whether or not there's going to be any vesting whatsoever on your founder equity. And if so, is it likely to apply to all of your equity, i.e. the shares that you've owned since incorporation, or does it only apply to your top-up equity, or maybe only a percentage of your equity? Let's say you were sort of a little bit naive about this and you didn't really understand, and you maybe closed a funding round last year, and it said in those documents that the vesting provisions apply to all shares held by all employees. So it includes you and all of your shares. And it maybe says that for 12 months from the date of adoption, 0% of your shares are vested. That could mean if you choose to resign in, the first 12 months from when you just closed a funding round, you may walk away with nothing. And obviously that would be, really unfair, but it might just be a slight oversight on your part, or on maybe, your advisor's part when you were negotiating with the incoming investor for your most recent funding round.
And I imagine here the technical way in which the documents are drafted really matters, because a resignation in this case might not be the same as the termination of employment under a settlement agreement, where a founder doesn't resign even though the employment is terminated.
Yeah, exactly that. The circumstances and the kind of actual facts about your stepping down or your stepping aside will be relevant, but take a look at your most recent set of documents. If the vesting provisions apply to all of your shares, and when did the vesting clock start? Typically it starts when the funding round completes. And if you're not careful, it may be the case that the vesting provisions apply to all of your shares. And it's fairly common that for the first portion of that vesting schedule, usually 12 months, nothing is considered vested. So there is a risk that you could potentially not have any entitlement to any of your shares if you resign at the wrong time.
Right. So again, lots of complexity, and tailored legal advice is crucial at this stage.
Definitely crucial at this stage, but also I think important if you're thinking at some point you might want to get out. Bear that in mind when you're negotiating with investors for your next funding round.
Gretchen, if someone would like to get legal advice from you as a founder, how do they find you?
Absolutely. We'd be very happy to help. So we're Lennon Legal. You can find us on our website, lennonlegal.com. You can find me on LinkedIn, Gretchen Lennon, or you can find Lennon Legal on LinkedIn, or you can just email me directly, gretchen@lennonlegal.com.
Cool. Thank you so much. I really hope that this conversation will be useful to many founders considering potentially stepping down from their founder CEO roles. And I'm very grateful to you because we covered so many really important and specific.
I feel like it was a bit of an onslaught.
Gretchen, thank you so much for your time today. I really appreciate it. And,
thank you for having me.
It was a pleasure.
Really enjoyed it. Cheers.
To wrap up our episode today, I would like to highlight 4 points. The first one is the importance of getting your own lawyer. It's really, really important to get legal advice if you are navigating a CEO transition, purely because of how many moving parts there are. Vesting provisions, tax, good and bad leaver clauses, options versus shares. There is a reason lawyers exist, and they can bring a lot of value, because it's easy to make some mistakes, especially when you're negotiating against investors and their lawyers who do it for a living. And as a CEO stepping down, the chances are that you're going through this process for the first time. Gretchen emphasized in our conversation that your lawyer has to be independent, as in you must engage them directly instead of using the same lawyer or the same firm that is acting for the company, because this is a clear conflict of interest. The second point I wanted to emphasize is the importance of signing a settlement agreement, even if the departure is amicable. The reason is that, again, there are so many moving parts. It's a good idea to wrap up the relationship in a very clear way, writing down everything that matters. The third point I wanted to make is the importance of understanding of how good and bad leaver provisions work. It might appear simple. After all, there are fairly short clauses in your constitutional documents. But the trouble is that there may be two different sets of good and bad leaver provisions associated with shares and share options. And there might have non-obvious tax implications, for example, taxed as income tax versus capital gains tax, depending on circumstances. There are different time periods when you can exercise share options, and depending on your situation, you may choose this or that option based on the legal advice you receive. And the final thing I want to say in conclusion to our conversation with Gretchen is that it's best to start thinking about this early rather than at the last minute. Maybe the biggest mistake to avoid is fundraising and then restarting your vesting schedule, which effectively means that if you leave half a year, or even 2 years after that round, you might lose a considerable portion of your vested equity. So if you are fundraising, if you got a sense that maybe at some point in the foreseeable future, maybe a couple of years from now, you might decide to step down as a CEO, it's important to think about it when you negotiate the legal documents with the incoming investor. This conversation has been quite technical at times, but I really hope that it will help our listeners to navigate this difficult legal territory when they are stepping down as CEOs. I hope you enjoyed the conversation. Don't forget to like and subscribe on the platform of your choice, and speak to you soon.